Good evening, I'm Breyer. It was the swing vote that nobody saw coming. Chief Justice John Roberts with the majority, upholding Obamacare. But did Roberts change his vote late in the process? And was the court prepared to strike down part of, if not all, of the president's health care law? Correspondent Shannon Bream has the story.
There are a lot of clues in the structure of the opinion that suggest that this may have been a late switch.
There are strong signals tonight that Chief Justice John Roberts may have flipped his vote in recent weeks to side with the court's liberal bloc, finding the mandate in the health care law a constitutional use of congressional taxing power, after initially agreeing with conservatives to throw out the entire law.
The dissent definitely does seem in places to have at least at one point been a majority opinion. You can see various verbal clues. One other notable aspect is the fact that they pointed out that the tax issue wasn't really discussed at argument. And so that suggests at least that it might have been a somewhat late-breaking development.
As legal scholars continue to digest the opinion, some assert that the dissent's many references to Justice Ruth Bader Ginsburg's, quote, dissent is telling, because she didn't write one per se. However, she did break from the majority opinion on key issues, so what she wrote that looks to be a concurring opinion could be fairly characterized as a form of dissent, potentially quieting speculation that she was in the minority at some point. The law supporters say the opinion simply proves that Roberts is truly functioning as the umpire he promised to be during his confirmation hearings, calling only balls and strikes.
I think that the Affordable Care Act opinion goes a long way toward saying that the Roberts court is not just motivated by politics, that at times they can put the law and the good of the country above their personal political preferences and do what the Constitution requires.
There was plenty of political pressure in play in the weeks between the time the case was argued in March and the release of the opinion on Thursday. The president's April statement in the Rose Garden that he was confident the court wouldn't take the, quote, unprecedented, extraordinary step of overturning the law. And the very public lecture by Senate Judiciary Committee Chair Democrat Patrick Leahy, who called on Roberts to put the brakes on a Supreme Court he viewed as increasingly political.
The Chief Justice is the Chief Justice of the United States, all 320 million of us.
If worries about the public's perception of the court did sway Roberts at some point, some legal scholars say that could backfire.
I think he's called the integrity of the court into question by at least having the appearance here, particularly as we talked about with the appearance that he may have switched his opinion late in the process. It appears to be a politically motivated choice rather than a legally motivated one.
Did the Chief Justice flip at some point because of political pressure? We may have to wait decades and for the release of internal court documents to get answers about exactly how this decision came together. But we do know this. Fox News polling after the case was argued showed 67% of those surveyed believed politics would definitely play a role in the justice's decision. Brett?
Okay, more on this with the panel. Shannon, thank you.
The dissent definitely does seem in places to have at least at one point been a majority opinion. You can see various verbal clues. One other notable aspect is the fact that they pointed out that the tax issue wasn't really discussed at argument. And so that suggests at least that it might have been a somewhat late-breaking development.
There are a lot of telltale clues that this dissent started out as a majority. There could have been 5 votes for overturning the entire mandate, and that at some time late in the process, the chief either switched his vote or finally came off the fence.
Many legal watchers, court watchers, going over this opinion by the Supreme Court very closely over the past 24 hours, and there are strong signals tonight that the Chief Justice may have flipped his vote in recent days, recent weeks, after siding with the conservative side of the court to throw out all of the president's health care law, then changing that to side with the liberal side of the court to uphold Obamacare. Let's bring in our panel. Start there. John Stossel of Fox Business Network, Juan Williams, columnist with The Hill, and syndicated columnist Charles Krauthammer. Okay, Charles, thoughts about this kind of reading the verbiage and about John Roberts' motivations?
Well, I'm not sure that we'll ever know. There's one piece of sort of psychological evidence, if you want, that when Justice Kennedy read his dissent, I wasn't in the room, but it was described widely as his demeanor as being either angry or agitated. Now, you know, these guys live with divided opinions all the time. You might expect that if he felt there was a reversal or even a betrayal. But that's pretty wild speculation. I think I should stop there. We will never know. I think what, to me, what...
We may know.
Well, in our lifetime, perhaps. But you know what's remarkable? You don't get any leaks out of this institution. I mean, the administration ought to learn. They held this so closely there wasn't anybody in the country who had a clue what was going to happen, and the way it worked out. There's nobody who predicted it, and there were no leaks. And from what I've asked around, it's about 50 people or more who knew this. You have that in the Congress or in the White House, and everything leaks. So I think we ought to entrust these people with Stuxnet and other cyber attacks.
The ruling was as the ruling was, and this is not to just go back into the motivations too much, but if that is in fact what happened, if these legal experts are right, reading as they read that the dissent could have been the majority one, what does that tell you about Chief Justice Roberts, if anything?
Well, first of all these smoke signals, clues, you know, I mean, I think really what we're talking about here is a big disappointment on the right with the decision and the feeling that somehow there has to be an explanation for this, and it has to be political. And I think what it tells us about Chief Justice Roberts in some minds, again, conservative minds, is that the ruling has less to do with the law than with his decision that it's time for this to become the Roberts court. It's no longer going to be the Scalia court. Anthony Kennedy's no longer going to be the swing vote. It's going to be Chief Justice Roberts who puts his imprint on this court and deals with the fact that the court was losing credibility in the American mind and becoming more and more taken as part of the very polarized and partisan politics that dominate this era of political life in Washington.
John, what's your thought of the majority opinion as it stood?
I don't presume to understand the Supremes. I don't even like lawyers. I'm glad we have now we have a clean fight in November where we can say, do we want the vision, the Juan vision of government taking care of us, or the, I think, Charles Stossel vision of markets doing more of it? So onward.
There is some quarter of the conservative folks out there who think that this is, in the long run, going to be an upside, because that Chief Justice Roberts essentially said the Commerce Clause did not affect this, and that this wasn't an expansion of federal power. I mean, do you see it as that?
I think we have to vote against expansions of federal power. I can't figure out what they were doing. The previous Commerce Clause case was this Roscoe Filburn, a farmer in Ohio who was growing wheat on his own land, not to even sell it for his own use. And the court ruled, well, because you would have bought it otherwise, this makes it hard. They were trying to raise the price at the time during the Depression, and we have the right to regulate that. So I thought that meant that the court would say the feds can do whatever they want to do.
Well, in fact, if you look at the history of Chief Justice Roberts on this point, it's just what John was saying. He is someone who has embraced the Commerce Clause all along. This is a break, but I think, again, today, this morning, the attitude was there are now going to be tremendous number of challenges to the Commerce Clause because it's become so expansive, and here is Roberts cutting back and potentially saying there's a limit to what the Supreme Court will allow under the Commerce Clause in terms of expansion of government. That government, in that sense, may have grown too large, and the future Roberts Court now, while liberals may be celebrating today, may rue this day because they'll find that Roberts now says, based on the way we were thinking previously, that Commerce Clause is not to be taken as opening the door to any federal action.
You agree with that? An upside for conservatives down the road?
I think so. I mean, I think people will say, well, then the government will expand no longer on the grounds of the Commerce Clause, which has been restrained by Roberts. It will expand on the basis of X, Y, and Z as a tax. However, there's a political difference between a fine and a tax. People don't like taxes. They kind of accept a fine here and there. If you get a speeding ticket, it's not called a speeding tax. People accept a fine as okay. And in fact, I think, well, you heard earlier in the show from Lindsey Graham, had the Democrats presented the mandate as a tax, it would not have passed in the House or the Senate. And that's precisely why the president kept saying it's not a tax, it's simply, you know, a mandate. So I think it will, practically speaking, make it harder because it'll be harder to expand the size of government and, under the guise of a tax, because people don't like taxes.
But this is a hidden tax. They'll pay it. They won't notice that they're paying it in many cases, or they won't get a new drug because we're taxing drug companies.
But if you wanted to pass the Roberts test as constitutional, you're going to have to call it a tax in the legislation.
Yeah. So White House Press Secretary Jay Carney asked about this numerous times, numerous ways in the press gaggle today. He said in one response about this, calling it a tax, quote, "You can call it what you want." He said it's a penalty, not a tax. Is this a problem for them, John?
I hope so. Penalties, taxes. It's 2,400 pages of micromanagement. It's a bad thing. It takes our freedom and our money. I hope it's a problem for them.
It's not a problem. Come on. Look, even Mitt Romney in Romneycare did the same thing, just what Charles described so accurately. Refused to call it specifically a tax, said it was an incentive for people to get health insurance, or a penalty on people who didn't get health insurance. And what we've seen is, I think, we had the little bit from Deval Patrick, the current governor of Massachusetts, where he says, what's it come down to is there are very few people who don't have health insurance who have to pay this penalty. I think he said about 1%.
Look, I think a fine and tax are really different. A tax is to raise revenue, a fine is to deter behavior. What Roberts did, I thought, was a very clever but rather hollow and I think not quite acceptable definition of a tax as being equivalent to a fine, which I don't think is going to catch on. I simply think, so he did it as a device, as a way to maintain the law while striking down the logic of the Commerce Clause. But I think in terms of reality, it's going to inhibit politicians from expanding under the guise of a tax simply because taxes are unpopular. But I think the muddled decision of this, effect of this law is going to have the effect of ratifying the axiom that a liberal is somebody who doesn't care what you do as long as it's mandatory. That's exactly what's happening in Obamacare.
Next up, we look at the politics of this ruling. Stay with us.